Hey folks, James Abrenio coming to you from Abrenio Choe. We are a criminal defense, personal injury, medical malpractice firm in Fairfax, Virginia. Today is January 16th, 2026. Wanted to shoot a quick video on what we call Nolle Prosses or Nolle Prosequis here in the Commonwealth of Virginia. Really explain what they are, when you can get them, and what are the implications if a Nolle Pross ends up happening in your case. Before I begin, a couple caveats. Number one, these videos are all for informational purposes only. You cannot rely on them as legal advice. I am not your attorney. If you have a question about your case here in Virginia, particularly Northern Virginia for criminal cases, feel free to reach out. But until we sign a retainer agreement, we are not your attorney. You cannot rely on these videos for advice, and you shouldn't, because every case is different, every fact is different, and it's just bad lawyering if you do. Secondly, if you find this information useful, make sure to like and subscribe and share. Trying to grow the reach of the channel, so always trying to help as many people as possible get more information about what's going on in their world. So let's talk about Nolle Prosses here in Virginia. Nolle Prosequis, and I'm probably mispronouncing that. I think it's Latin. But in order to understand what they are, I always first of all go to the code. And so just when we're talking about the circumstances of when a Nolle Pross may be relevant in your case, if you've been charged with a crime, you're going to court, you're at a trial date, or you're leading up to a trial date. Sometimes this happens on the date of trial. Sometimes it happens before trial, and the Commonwealth makes a separate motion. And the Commonwealth here in Virginia, that's the prosecutor, that's the district attorney, they will move the court to Nolle Pross your case or effectively end that case. And when they do that, typically it is a Nolle Pross without prejudice, meaning if they so choose, it can be brought back. Now, there are certain circumstances where I, as defense counsel, I'm representing somebody and the Commonwealth says to me, look, I want to go ahead and Nolle Pross this case. The Commonwealth doesn't want to go forward. And many times that's a great result. I don't, and the reason being, in a particular circumstance, I don't typically have a specific reason to believe that the Commonwealth will bring that charge back, reinitiate that charge. And so many times we will be well aware of the prosecutor's position as to why they want a Nolle Pross. And it may be because they look at the facts of the case and say, look, we just don't think that there's a good faith basis to go forward. We don't believe that there's probable cause to go forward. We don't have a good faith basis to believe that we can earn a conviction. It may be it's part of a plea agreement. So, hey, if you do these many hours of community service or do anger management or whatever the case may be, we'll come back and we'll Nolle Pross the case. Maybe, there's some reason from a justice standpoint that the Commonwealth looks at a case and says, look, I just don't think this case is appropriate to go forward, even if I can earn a conviction. I do a lot of domestic violence cases. A lot of times I will represent women, for instance, who have been actually charged with domestic violence. And unfortunately, what ends up happening is we'll have a manipulative spouse that will essentially trigger them into or convince them into committing some nominal assault in Virginia, which can be a slap, can be a push, can be throwing of water, things like that. And it will be just enough to meet the threshold. And of course, in these scenarios, unfortunately, that I run far too often across, you will have situations where that spouse or that significant other has kind of goaded them into committing assault. And sure enough, they happen to be recording it or they have their cell phone out, and then they get them charged in an effort to either just be mean spirited against that person, or maybe there's a divorce and they want to use that to benefit them. Maybe there's some other thing that they're trying to use. So it may be that a Commonwealth attorney looks at it and says, look, I'm going to Nolle Pross. I don't think it's appropriate to go forward. And again, I, as defense counsel, don't have a reason to believe that the Commonwealth will bring the case back. Also, remember, when it comes to misdemeanors, there's a year statutory statute of limitation. So if a Commonwealth says to me, I want to Nolle Pross the case, and I don't have any reason to believe they're going to bring it back, I know that in theory it could be brought back. It's likely not going to be brought back, but even in worst case scenarios, there will be a year statute of limitations, so the client doesn't always have to worry about it. Felony is a little bit different. But again, you'll usually, as defense counsel, get a sense of whether or not you have concern about it being brought back. So this video is really concerning when you're worried that the case will be brought back. And so there may be a reason that I don't want the Commonwealth to get a nolle pros, because I know that all that's going to lead to is the case being dropped, an issue, a warrant being reissued, or an indictment being reobtained, and then my client having to be rearrested. And effectively, what's all that's done is either put the Commonwealth in a better position because maybe they were missing a witness, or put my client in a worse position because now they've had delay of the trial. It's been hanging over their head even further, and we were prepared to come to court. So there are circumstances where we show up to court ready to try a case, and a Commonwealth will say, for whatever reason, Your Honor, we want to move to nolle pros the case. And I now, in this scenario, am in a position where I'm objecting to that because I don't want a nolle pros. What I really want is the court to say, you don't get the nolle pros, and then the Commonwealth is forced to then dismiss the case because for whatever reason, they just know they can't go forward. Maybe it's a key witness. Maybe somebody's recanted. Maybe their expert, has pulled out, something like that. And I know that if the Commonwealth gets an opportunity, they will try to fix that and then re-bring it. Okay. So we're talking about scenarios where the Commonwealth has moved. What they'll typically do is they'll actually move to continue the case first. So they'll say, Your Honor, whatever flaw we have going on, we want to continue the case. I will object because, in my view, there's no good cause and we're prepared. And the Commonwealth will argue to the court why the court needs to grant the continuance. And the scenario oftentimes is the court will not grant a continuance. They'll say, okay, Commonwealth, we are not going to grant this continuance. And so in continuance in Virginia, just to be clear, is to postpone the court date. So it essentially allows the Commonwealth to get whatever witness or evidence they need there. So then you have this scenario where the Commonwealth will then move to nolle pros or drop the case. And my argument is they should not be able to nolle pros the case. And a lot of times my clients think that, well, we're in a winning spot. But unfortunately, they're not aware of the statutory framework that oftentimes is set up to where it can be difficult to win an argument that a nolle pros should not be able to be granted. So first of all, whenever we're looking at issues, always go to the statute. So here I'm at lis.com or lisvirginia.gov. This is where you can find our codes, and I am oftentimes looking at that when I'm not looking at specific research software like Lexis. So here is the statute, Virginia Code 19.2-265.3. I'll link this in the show notes. Nolle Prosequi, we call it nolle pros, discretion of court upon good cause shown. Nolle Prosequi shall be entered only in the discretion of the court upon a motion of the Commonwealth with good cause therefore shown. And so when you look at that, you think, well, that should be pretty easy as a defense attorney to win because it is on the burden of the Commonwealth to show good cause that a nolle pros should be shown. And you would think in your mind, well, unless there really is some issue that is preventing the Commonwealth from doing their job, we're probably going to win this. But unfortunately, the case law is not as good as we'd like to believe. And so what I'd like to do now is share a case that is really a seminal case when it comes to nolle prosses here in Virginia. This is Duggins versus the Commonwealth. And this is the reporter number, Virginia VA App 785-2012. What that means is the case was decided 2012. VA App means the Court of Appeals. So in Virginia, there are generally three trial courts: the Circuit Court, we're talking about felonies, the Court of Appeals, the mid-level, and then the Supreme Court. And when the higher courts above the Circuit Court make a decision, those decisions are binding on the trial court. So here, the Court of Appeals really is giving guidance to trial courts considering when they can or can't grant an nolle pros. Duggins is really a case that they oftentimes will look at, that really lays out. And again, as a defense attorney, I'm not always, this case can be very difficult to have a client understand. And frankly, from a logical standpoint, I will be honest, I don't really understand it. It seems to put the onus more on the accused than the Commonwealth. But again, it is what it is. I'm not a judge. I don't get to make these decisions. I'm just trying to educate folks about, again, information purposes about what the case may be. Again, if you have your own case, you have your own facts, you should talk to your own attorney to get your own specific advice. So this is a synopsis following the Nolle Pross, and I'm just going to call it Nolle Pross to make it easy. Nolle Pross, a first indictment on 2 counts of fraudulent use of credit card. Defendant was reindicted and following trial convicted in the circuit court, Fairfax County. Bruce White, the same charges. Defendant appealed. So this is out of this jurisdiction that I'm sitting in right now. Bruce White has since retired, but he was a well-known judge, pretty smart judge. Smarter than I. The Court of Appeals held that Nolle Pross of indictment following denial of the Commonwealth's motion for continuance did not bar reindictment for the same offenses, regardless of whether the trial court ruled that there was not good cause for the continuance. And so this defendant here, their conviction ended up getting affirmed. So they had moved to Nolle Pross, and we'll talk about it in a moment. The trial court said, no, we're going to allow the Nolle Pross. It got reindicted, and then they were ultimately convicted. And here the Court of Appeals is considering how fair that was in the first trial and said, no, you're convicted. I've highlighted a few aspects of this case that are important. You can read it for yourself. Lauren Whitley, I think she's actually now the chief public defender down in Richmond. Very good trial attorney. Again, Bruce White was the trial judge. And so here are the facts. A jury found that Duggins guilty of 2 counts of fraudulent use of credit card. On appeal, Duggins claims conviction should have been overturned because the trial court in a prior proceeding erroneously allowed the Commonwealth to Nolle Pross indictments alleging identical charges because these charges should not have been dismissed without prejudice, meaning the trial court there should not have allowed them to be brought back. Duggins' reasons the new indictments alleging the same charges in the later proceedings should have been dismissed with prejudice. We disagree and affirm. So just a quick factual circumstances. In September 2009, a grand jury indicted Duggins, alleging 2 counts of credit card fraud. Shortly before trial, the prosecutor requested a continuance. He explained that a cooperating witness with relevant documents had agreed to appear at trial and was willing to accept a subpoena served by telefax. It's 2012. I guess faxes are still more prevalent. The prosecutor said he telefaxed a subpoena, but the witness later claimed she never received it and stated she would not appear at trial or produce documents absence of a properly served subpoena ducis tecum. The trial court denied the continuance motion. So here you have a scenario where you have a key witness for the government. Instead of actually formally serving that witness, therefore allowing compelling power, allowing the court to hold them in contempt, they served it by fax. And so just from a factual standpoint, this is why it is rare that I will agree, if it's a key witness, that I will agree for a witness to just hand deliver a subpoena. Therefore, it's not legally effective. In order for a subpoena to be legally effective in Virginia, there's proper avenues, either personal service or serving by posting on their front door. But you have to have it served by a legal process server, not fax. And so here, the Commonwealth, the prosecutor took a risk by saying, look, I'm not going to serve it by the formal thing. I'm just going to send you a fax. You agree, we're good. And then there became a factual dispute. And the judge said, look, that's not effective to force me to give you a continuance, to force me to bring, to get the sheriff to go arrest this person and bring him to court this afternoon. And so in my view there, by from defense counsel, which was argued, it is the Commonwealth's burden to properly get their witnesses together. We, defense counsel, are ready for trial. They took this risk by not properly serving this person. So it is no longer good cause for them to get a Nolle Pross just because they didn't do their job. Okay, they have all the resources in the world. They could have easily got a sheriff to go serve this document. It would have been very easy to do, but they didn't do it. And so the defense here, the appellate defense attorney, is saying, look, this should have never been allowed to, the trial court originally should have never allowed a Nolle Pross without prejudice, meaning they dropped it and then were able to bring it back. The court should have never allowed that. It should have said a nolle pross with prejudice, meaning you can't bring it back, or denied it altogether, and then the Commonwealth would have had to dismiss the charge. And you would think that that's not good cause, because again, we're looking at the nolle pross statute. Let me just reshare that again. A nolle pross shall be entered only in the discretion of the court upon a motion of the Commonwealth with good cause shown thereof. So you would think that the onus is on the Commonwealth, and here the Commonwealth could have easily gotten it served. They didn't do their job. You think that we'd be in a good scenario if you're defense counsel, but of course they affirmed his conviction. So we're going to read why. Because of the witness's last-minute retraction, the prosecutor moved the nolle pross charges. Finding good cause to do so, the court agreed and dismissed the charges without prejudice. Again, they can bring it back. The final order stating all proceedings in this case were terminated. The defendant was released and discharged, amended. And so then later on, because the prior court found no good cause to grant the continuance, Duggins contended it necessarily follows the court improperly found good cause for the nolle pross. So essentially, the defense attorney's making the argument they should have made. You, the court, are not giving them good cause to grant the continuance. Therefore, there's no good cause to allow them to nolle pross without prejudice. That didn't work, obviously. So, and then let's read. The trial court presiding over the January 2010 indictments denied Duggins' motion to dismiss. The case proceeded trial and jury found guilty. So now the court is getting into the history of the nolle pross. A concept dating back from the late 1600s, nolle pross means unwilling to prosecute in Latin. Under English common law, the public prosecutor could generally enter a nolle pross in his discretion without obtaining the trial court's permission. Some common law jurists, however, including Lord Chief Justice Mansfield, reserved the power to overrule a nolle pross when wielded as a weapon of mischief, oppression against the accused. Now we're talking about when the Virginia General Assembly passed the nolle pross statute. In 1979, the General Assembly codified the tradition in 19.2-265.3. And again, that's a statute referring to. Under this statute, a trial court has the discretion to refuse a nolle pross if the prosecutor fails to show good cause consistent with the Commonwealth common law background. Virginia trial courts properly refuse nolle pross when the circumstances manifest a vindictive intent. So not just, oh, the prosecutor messed up, but they actually were affirmatively being vindictive, resulting in oppressive and unfair trial tactics or prosecutorial misconduct. Absent such mischief, however, the courts defer to the public prosecutor given his constitutionally recognized prerogatives, meaning, in theory, a prosecutor is supposed to seek justice. In practice, does that always happen? I think if you're paying attention to the news and the national news, you can see when that's really an amplified version of how justice can go wrong. But at the state level, in these smaller cases, it happens too. It's just not as sexy. It's not all over the news. The executive remains the absolute judge of whether a prosecutor should be initiated and the first and presumptively the best judge of whether a pending prosecution should be terminated. The exercise of its discretion with respect to the termination of a pending prosecution should not be judicially disturbed unless clearly contrary to manifest public interest. In this way, the essential function of each branch is synchronized to achieve a balance that serves both the practical and constitutional values. Such deference remains due even in cases where the prosecutor seeks a nolle pross because of an oversight in its pretrial preparations or lack of adequate foresight and preparation on the part of the Commonwealth attorney. In such circumstances, the interest of justice of both sides, prosecution and defense, adequately prepared to address the merits of the case. So again, we're talking about this case, and this case, the facts of this case make sense, at least in the ruling, that even if they oversight, and that's the reason they need a nolle pross, that's still not going to get past the good cause issue, and they'll still be granted the good cause. Now, I did want to highlight here, this is, there's a footnote here. The court notes a footnote, and we're going to zoom down here real quick. Footnote 5. dicta, in footnote, in battle suggesting otherwise, as well as unfamiliar, similar reasonings later, dissenting opinions have rejected, adopting panel have been superseded by Virginia Supreme Court decision in Harris. And I may do a follow-up video there. But I think what that footnote, at least in this case, is saying is we're going to leave a little bit of room because this, in my view, is dicta. What is dicta? Dicta is when really the court's going beyond the facts of its case. And so, there's an argument here, at least in my view, that this case isn't as strong as it seems. But, it kind of, again, they're putting that footnote there. That is for if your lawyer is arguing this case to look in deeper dive. But I just want you to have a general idea of what's going on here. So now we're in a scenario is in Duggins where the question always is the Commonwealth Nolle Pross case. Let's say you've got your charge of Nolle Pross. Is the Commonwealth then going to subsequently bring a new charge based on those same facts? That's what you're always concerned about. And so here, the court goes into effect on subsequent prosecution. A Nolle Pross discharges the accused from liability on which the Nolle Pross is entered, but does not constitute an acquittal or discharge from further prosecution. Under limited circumstances, a Nolle Pross could implicate a bar to subsequent prosecution. For example, the constitutional prohibition against double jeopardy might be triggered if a Nolle Pross is granted after jeopardy attaches. Now, just to be clear, that's a very factually specific scenario. Jeopardy is a very specific legal term of art when not just because I'm sure people have heard of double jeopardy. The government can't recharge you for the same crime. They can't get two bites of the apple. But jeopardy doesn't attach just because you're charged with a crime. Jeopardy really attaches the most traditional way when a case actually starts. So once, the jury is picked and you start opening statements and all that, that's when jeopardy really attaches. So if, let's say, the witness starts testifying, the opening statements have been made, and then all of a sudden the Commonwealth realizes, oh my goodness, my star witness, got in a car crash and now at the hospital, right? And they're not going to be able to come and, they're in a coma or whatever. Once jeopardy attaches, the Commonwealth can't then move to Nolle Pross that case. Now, they can try to continue it, but they can't move to Nolle Pross because that's no longer good cause. You can't then retry it because that'll be double jeopardy, right? Now, again, the Commonwealth in that scenario will probably try to continue it to try to get the witness there. But if they Nolle Pross, that's effectively done. So this Duggins case is saying, hey, look, we're not saying that that Nolle Pross means you automatically can bring it back. There's still constitutional limitations. In addition, a Nolle Pross could contribute towards a prejudicial delay in defendants' constitutional speedy trial protections against Sixth Amendment. So you have the right to speedy trial. Once they Nolle Pross, the speedy trial starts running again, so they don't just get to keep it out indefinitely. Finally, when a Nolle Pross is issued as an unconstitutional weapon of prosecution, misconduct, subsequent enhanced charges could be dismissed as a remedy for a constitutional violation. So what that is saying is the court's leaving a little bit of room to say, look, there may be factual circumstances dealing with the particular Nolle Pross in your case, dealing with the particular behavior of the prosecutor in your case, where they're clearly being vindictive. They're clearly trying to use the process against you. So for instance, let's say you object to the Nolle Pross. The court says, no, there's good cause. And then all of a sudden now they're enhancing the charges to essentially punish you for objecting in the first place. That's kind of a scenario that I'm thinking about. But again, this is why you need to talk to your own attorney in your own particular case, because every fact's different. Every judge is different. And so it's not like that's a case that I'm aware of. It's just something I'm thinking about as we're looking at this case law. So it's something to think about. Okay. To begin with, the earlier Nolle Pross decision was made in an entirely different proceeding. It cannot be revisited after initial proceeding becomes final, and it is incapable of reconsideration under Rule 1:1. All the more, it cannot be collaterally attacked as subsequent proceeding. So what the Court of Appeals is saying here is, and if you, in Duggins, if you follow what happened is you had an initial case, moved to Nolle Pross, objection, it was granted, and then a new case came out, and then the case was prosecuted. What the Court of Appeals is saying is look, we also can't go back and look at that initial trial court that granted the Nolle Pross without prejudice, because that's an independent case. That's an independent action. We don't have the authority to then go back and look at that preceding trial. They made the decision they're going to make. If you didn't like that, I guess in theory, you could have appealed it at that point. I don't know how far that would get you, but waiting until a subsequent trial, it just isn't enough. We don't have the authority to do that. Equally important, the trial court in subsequent proceeding can impose no effective remedy as to the earlier terminated prosecution, even if the earlier no prosecution was arguably entered in error. And again, the Court of Appeals is also saying that subsequent trial court can't look at that subsequent Nolle Pross, that separate case. Let's see. The court cannot dismiss with prejudice an indictment subsequent proceeding merely because the same charge had been dismissed without prejudice. Such an exaggerated remedy would be disproportionate to the aligned error. So that's really the important case that you need to be looking at if you're thinking about Nolle Pross and this question. Now, in practice, what does this mean? Okay. If I'm representing somebody and I go to court and we're ready to try the case and the prosecutor says to me, James, a key witness is not here, we want to continue the case. Typically what I'll do is say, I'm not going to allow you to move to continue the case because you just didn't get the witness here. I'm going to object to that. A judge may or may not grant the continuance. A lot of times it'll depend, and I'm talking anecdotally here. This discussion is really what I see in practice. And it's really dependent on the particular facts of the case, depending on the judge, very different in different jurisdictions. And so I'm just talking kind of generally what I see. What I see generally in a scenario like that is the court will look at the reasoning behind why that witness is not there when they're considering the Commonwealth's motion to continue it, to try to get a witness there, to get a piece of evidence there. And they'll say, can you tell me what is the issue? Now, let's say it's an officer and the officer is out because they're sick, they need surgery, their family member died and they've got to go. They've got a serious medical procedure that was unpredicted, that kind of thing. The court is typically, at least the first time up, in my experience, going to grant a continuance. And I'll say on the flip side, a lot of times when I, as defense counsel in the same scenario, the court will typically grant me a continuance as well. If I have a legitimate reason why a witness is not there, a medical reason, something that's not because just, somebody was asleep at the wheel, something like we decided to fax over the subpoena rather than actually subpoena them. I don't think a Commonwealth is usually going to be able to get a continuance in a scenario like Duggins in that situation. Now, when we're talking about then, let's assume that the judge says, you know what, you didn't send out your subpoena, we're not granting a continuance. Now the Commonwealth will then move to Nolle Pross the charge. And then that will be then the question of that trial court to decide, well, I want more facts as to why you didn't move, why you didn't get the witness here. So like a good argument would be, let's say the Commonwealth just did not subpoena the witness, right? They didn't subpoena them at all. And they're saying, look, under Duggins, I should be able to get the Nolle Pross without prejudice so I can bring it back. What I would be arguing there is, look, Duggins is a very specific fact scenario where they actually had a witness agree they were going to come. They actually at least faxed them that subpoena. So the question really is, did the witness actually receive it or not? So there's some effort there by the Commonwealth that they try to get them. If they just didn't send the subpoena out at all, that's a very different scenario, right? I would argue. Now, a lot of times the judge will still grant them that Nolle Pross without prejudice, and a lot of times the Commonwealth will then bring back that charge. But some judges may not. I mean, again, judges have a lot of discretion, and I think that's also another important point in Duggins when you're considering if you're arguing Duggins against the Commonwealth. It's not like Duggins says you have to do this in this scenario. Duggins is still saying the trial court has discretion. Your particular trial court has discretion to determine what is vindictive, what is unfairly oppressive, all that. So just keep that in mind if you're counsel and you're looking at this scenario. Now, another thing from a practical standpoint that you want to consider if you're probably going to lose the Nolle Pross argument, the court is probably going to allow the Commonwealth to Nolle Pross a charge. The question becomes is, does your client, do you as an accused person want to have to be rearrested and go through that whole process again? By now you've been arrested, you see what it looks like. Now your criminal record is going to have 2 charges instead of 1, that kind of thing. From a practical standpoint, that's something you'll also want to talk with your attorney about in that, if you're in that very specific scenario. Now, there may be situations where I, as defense counsel, may say, look, screw them. I want to force them through every step of this because I think that this case is so flawed that it should never be brought in the first place. And if they want to go through this, we're going to force them through it. Also, I think, maybe it was a very close call and all that. And maybe the witness is not there because they ultimately don't want to come back, right? Things like that. So it may be that, you'd rather, even if the court says we're going to grant the Nolle Pross, well, Your Honor, just go ahead and continue it. I don't want to be rearrested. That may be a scenario that you may want to have a discussion with your attorney about. Again, this is all the more reason why you need to speak with your own attorney about the facts of your case. Because every fact is going to be different. Every judge is going to be different. Every prosecutor is going to be different. Every officer is going to be different. Motivations, willingness to put in the work, all that stuff factors into, if I'm in that scenario and I'm counseling my client about what we should be doing next, it all plays in. So hopefully this information was useful for you. Again, don't take this as legal advice. It's not legal advice. If you have questions about your own case, feel free to reach out to us. I will say I'm not going to second guess the current attorney. If you're looking for an attorney, reach out to us. I'm not just going to give a second opinion. Look, if you decided you want to move on, sure, we'll talk to you. But we're not in the business of putting second eyeballs on cases, because either you trust your attorney or you don't. You don't want to be midstream and then start doing this waffling. I think that's bad for everybody involved. But hopefully you found this useful. If you have questions, comments, make sure to comment below. Make sure to like, subscribe, and share. Wish you guys the best.